Guys, welcome back to the Kempire channel.
Here we go now.
And as you know, we've been covering the Sean Diddy Combs case since the beginning. And our next guest has been here before to give you a prosecutor's perspective on this trial. So I told you, Kirsten Brown had to come back. And so here she is. Kirsten, what's going on?
Hi, Kemp. I am thrilled to be back and dive into this and answer questions that your community has.
Ooh, they have a lot.
Let's get into it.
So before we get into it, I do want to remind people that Kirsten has been here before, and we had a great, almost 2-hour conversation talking about the first couple of weeks of this case. So there might be some stuff that we won't go in depth. So I'm imploring everyone to go back and listen to it. I'll link it in the description, or you can listen to it on the podcast as well. We will revisit some stuff just because it just feels prevalent to the last few weeks of the case. But before we get into that, Kirsten, tell people about yourself and your expertise.
Absolutely. I am a prosecutor with the Los Angeles County District Attorney's Office. I have been a prosecutor for over 12 years, about 12 and a half years at this point. And almost all of my career has been devoted to sex crimes of adults, sex crimes of children, human trafficking, as well as domestic violence. And that includes some domestic violence murders and some of the really horrific cases that come out of that area of the law. I am incredibly passionate about this work, and I find that it disproportionately impacts people of color, at least the cases that I have do. So being an advocate for people who look like us and just women in generally, not that men can't be victims. We talked about that before too, but in the context of this trial, we're talking about women, but just being an advocate for women is something I am super passionate about. And so watching this Diddy trial is exhilarating, but also triggering, because it is like being at work on a daily basis, just at a state court level rather than the federal courts.
Yeah. Which is what Diddy is facing right now.
Correct.
Still, people are saying, even how many weeks later, and I'm interested because I have not talked to Kirsten about where she is when it comes to how this case is going. I purposely have not asked her because I'm interested, because one of the things that you said the last time that you were here was the fact that you felt like Cassie Ventura, Diddy's former girlfriend, and who a lot of people felt is the one that sparked all of this that we have from her lawsuit. You said, not a popular opinion, that you didn't think that she was the star witness. Now we are at the end of the prosecution. They should rest this week, despite today they had to cancel proceedings because a juror had vertigo. God bless them, because that's the worst.
I hope they're okay.
Yeah, so they had to cancel for today, and then Juneteenth, of course, is a federal holiday for now. But, I have to keep saying that, unfortunately.
It's true, though. It's true.
Just don't know. But you said that you felt like Cassie Ventura wasn't the star witness, especially with her testifying so early on. Now that we're towards the end, and Christina Curran has not testified, because I have to understand, I need to pick your brain, why? But now that we're at the end of the prosecution's case, how are you feeling about the case? Do you still stand on that you don't feel like Cassie Ventura was the star witness?
To be honest with you, I think I may have been wrong about that. And that now that we've seen all of the prosecution witnesses, it turns out that Cassie was kind of the hammer to all of this. I really was expecting more employees. I think, like the rest of the world, where is KK? I really expected them to call her. It is very surprising that they haven't, although the text messages that include her are almost like her testifying without being here. So they're still getting in. It's like her and the baby oil are the unseen parts of this trial. It's the two things that keep coming up all the time. And, you know, we don't need the baby oil in court, but where is she? It's very surprising that they're not putting her on, or any security guards, or more
T-Rock's name has been brought up multiple times.
Right. And when you have subpoena power as the government, it's not like you need people to cooperate to come into court. You issue that subpoena, it's a court order, and they need to show up.
Yeah.
And they don't even necessarily have to be cooperative witnesses in the sense that they get on the stand and sing like a bird, because there's so much documented evidence and testimony from other people about their involvement. And then, two, you're sort of dangling over their head potential charges, which sometimes coerces, appropriate here, coerces someone into reluctantly giving the information that they need to. So it's very surprising. I've heard some speculation that they might put her on as a rebuttal witness. I think
explain what that is for those
sure.
that understand what that is.
So
layman's over here.
Of course. So what the prosecution is doing now is called their case in chief. It's their main case. And then the defense puts on their case. Now, remember, the defense doesn't have to do anything at all. They don't have to put on any evidence. They don't have to put on any witnesses. And then, of course, Diddy, it's constitutionally protected from having to testify if he doesn't want to. The defense could simply make arguments that the prosecution did not meet their burden. They don't have to affirmatively put on anything. But it sounds like they are. So when the defense does put on witnesses, the prosecution is then allowed to put on what's called a rebuttal case. So you can put on additional witnesses to rebut or refute information that the defense just put on. And the prosecution gets that second opportunity because the prosecution has the burden. They're the ones that have to prove everything. The defense has to do nothing.
Wow. But they are planning to call their own witnesses.
They are. What did they say? It's going to take 2 to 5 days, which is going to put it's going to put the trial sort of bumping up against that deadline that the
July
judge
4th.
had mentioned before. And not that you can't go beyond that, but judges start getting real antsy, and jurors start to get antsy because mentally you've told yourself it's going to be winding down, if not over, by this date. And so they're kind of like, what are we doing here? So if the prosecution waits to put her on as a rebuttal witness, you run the risk of not being able to get into everything you wanted to. You can only rebut what the defense did. And the judge might be really trying to push things along because the prosecution has to finish the defense case, probably a full day of the attorneys just discussing jury instructions, pre-instructing the jury, and then closing arguments. We are easily getting up to the 4th of July with that alone.
Wow. Damn. Thank you for schooling us on that, because it does seem like, and you can tell me your opinion now, especially after a few weeks of us seeing how the judge controls his courtroom.
He runs a tight ship.
Yeah, he was definitely on the schedule. Are we going to be on schedule? Are we going to be on schedule so far? So that definitely reigns to be true in regards to them trying to stay on schedule. But in what world does Christina Kerm not testify? I did hear, and I don't know if this was in court documents, because there are a lot of court documents when it comes to this case, that they're considering her an unindicted co-conspirator. Have you heard that?
I have heard that. I've heard it in passing. And so that means that they could bring charges against her. Maybe they will, like the Epstein and Ghislaine Maxwell case where she was indicted after he was. They certainly could. I think it would be surprising, especially because Diddy is sort of at the top of the food chain. If you think about it like a pyramid, about how they built the case. So to indict someone after him would be surprising. And it would be also hard to imagine that she testifies as a defense witness, because then she's not protected by any immunity, and it's open season for the prosecution to ask her about things, and then she couldn't claim the fifth at that point. And I've also heard, again, just in passing, that she's represented KK by Tenny Garagos, in addition to Diddy obviously Diddy being represented by Tenny Garagos. That's unconfirmed, just something I've heard on the internet streets.
Okay. I haven't heard that.
If true, that's interesting as well. And then for a hot minute, I was like, what if KK is victim number 3 and she disappeared? But
I've heard, and I think literally I read something in regards to the court documents that actually victim number 3 is Gina, a woman that dated Diddy several years ago, did an interview with Tasha K like 5 years ago, confirming Cassie's accusations before Cassie even came out with her accusations. but now they have removed her as a witness. There were rumors that she has gone missing. Have you heard
Right.
anything in regards to that?
Nothing, I think, beyond what you've heard as well. It is not uncommon to not find all of your witnesses or have all of your witnesses at the start of your trial. Trials are fluid.
Yeah.
And you want to have everybody ready to go, but to lose contact or be uncertain if someone's going to show up is not uncommon at all. I expected them to find her because there's a lot of resources that they have at their helm. And it's hard to, if you are a normal person with bank accounts, kids in school, you've ever gotten any kind of check from the government, including like a tax refund, like all these ways that investigators can find people, it's very hard to go off the grid if you're a normal person. And for her attorney to have not been available or reachable was very odd. And then two, for the defense to be so definitive in their remarks to the court, this was a few weeks ago, victim number 3 is not coming. Well, how do you know?
Right? They're not your witness.
And now, mind you, there's nothing prohibiting them from talking to her. So they very well could have. And she told them, yeah, I'm not coming.
Oh.
So, and they're not required to tell the prosecution. We spoke to her and she said she's not coming.
And if victim number 3 spoke to the defense, there are, of course, speculation that maybe she was paid off.
Right. Now, they can't do that legally. There's no bribe.
Well, no.
Paying her off.
Yeah.
But there would be nothing prohibiting one of the attorneys, or I'm sure they have a team of investigators as well, contacting her and just saying, are you coming to court or are you not coming to court? Or it's, again, this is bald speculation, but I thought it was very interesting that they have not been able to track her down, that they're not putting KK up, that they're not putting D-Rock up, or just more Combs Enterprise employees.
Yeah.
Although it sounds like the text messages covered a lot and maybe closing some of the loops on the racketeering conspiracy.
Based off of them not including some of these important, some might say, employees and how the case has been going since the last time that we spoke, I think we both agreed the last time that it was still too early to definitively say the prosecution has proven their case. This is a wrap for Diddy. Now that we're on week 6?
Right.
How do you feel about how the prosecution is doing versus the defense?
Okay, so I'm going to oversimplify this by way of analogy. Think of 2 types of cases, 2 types of criminal cases. And you have one, let's say, Kemp, you are walking down the streets and someone knocks you over the head, steals your backpack, and then runs off with it, but you get a good look at that person. That person is ultimately arrested. They're found with your backpack and a gun, and you go to trial and you tell the jury, that's the person who knocked me upside the head and took my backpack and pointed a gun in my face. And the person is charged with robbery with a gun. Just hearing from you alone is going to do it for the jury. They understand what a robbery with a gun is, and they hear you testify and they're like, okay, great, we can convict. There's other kinds of cases where you hear a lot of really, really bad facts and a lot of information, but you don't understand what the theory of criminal liability is. And I think with this case, the prosecution is really going to have to come home in their closing arguments and explain the theory of criminal liability and explain to the jurors how they analyze all of these horrible facts they've heard about Diddy and apply them to the law, and then ultimately they'll ask for a conviction. To put that in a real life example, I had a murder trial a couple of years ago that was the basis of a fatal car accident. Horrific, tragic accident where 2 people died. So the juror comes in and they hear a double homicide, 2 murders, but then they're like, wait, a car accident? Like, how do we get from a car accident to murder? And so we go through the whole trial. They hear the horrific way that the 2 victims died. And then I get up in closing argument and I'm like, this isn't just a fatal car crash. This is an implied malice murder. That's my theory of liability, because this defendant who was street racing, driving 120 miles per hour on a surface street, hit the back of the car, it exploded, and then he fled. He was acting so recklessly and with a disregard of human life that it was probable that someone would end up dead. Like, that's not the way people commonly talk, and it's not what you think about when you hear murder, but that is a theory of murder, and I had to argue that to the jury. So at the end of my case, they're like, we know 2 people died. It's sad. It's really bad, but I don't know how we get to a conviction. So it wasn't until I explained the law that got them there. And I think this RICO case and the sex trafficking is the same type of thing. The prosecution's really going to have to explain their theory of liability so the jury understands how to interpret all of this bad information that they've heard about Diddy.
Okay. Wow. Thanks for explaining that.
I know that's a lot because it's the elements are there. Remember, we talked last time about there's a long list of bad acts, predicate acts that qualify under RICO, and they checked a lot of those boxes. But is that going to be enough for people to understand how Bad Boy Combs Enterprises was a criminal enterprise operating to commit crimes? And so the prosecution has some more work to do to make it make sense, I think.
Based off of all of that, how do you feel though, if you were to make a prediction on how this would end up now that we're on the 6th week? Where do you feel you are versus where you were maybe a couple of weeks ago?
I don't feel like, having solely heard the testimony of the witnesses, I'm there, it's done. I really want to hear how they tie it together, but it's with the caveat, like we talked about before, not being in the courtroom and only getting summaries based on other people's interpretations. Even as good as yours are, it doesn't tell us how it's landing in the courtroom. And it doesn't. Sometimes too, if you have non-lawyers reporting back what they hear, you don't always report everything, and you may have missed something that's super relevant that you wouldn't understand as an attorney, right? Like, something could have been crucial and it sounds like a throwaway piece of information to you as a journalist or a layperson, but as a lawyer, like, that piece right there was key. So it's hard to know without seeing jury reactions and without hearing every single piece of information that the prosecution presented. It's hard for me to say definitively that's it, they got it, it's done. But I think all of the elements are there for a strong closing argument. That being said, the defense has done a good job. They have effectively cross-examined some of these witnesses to the point of being like, well, that person might just be a wash. You know, Mia, her testimony might end up just kind of being a wash when it's all said and done.
Why do you say that?
She wasn't as definitive as Cassie was with there wasn't as much violence. There was a couple of violent episodes, but not as much as there was with Cassie. And she didn't have the same sort of definitive way of saying, or even implicitly saying, I don't want to do this. Although some of the text messages that come in seem to indicate that. So again, without the whole picture, it's hard to say. And there's so much about Cassie that you could empathize with in terms of her age, the fact that she was signed to Bad Boy and was supposed to be putting out all these albums, that you understood why she stays, even setting aside the cycle of violence. Whereas with Mia, she was a little bit older when they got together, and there wasn't as much physical violence.
I think you're referring to Jane.
I'm sorry. Jane, yes, I'm sorry.
Mia was the assistant. I know it's hard.
Yes, there's so many people. And I actually at one made a chart, but I don't know.
I literally should have a chart in here just to keep up. And I don't know how. Okay, good memory. Okay. Mia is the assistant that he also sexually assaulted. So that's why it's easy to mix it up, because
he was just out, hide your kids, hide your wife. He was raping everybody out here. Wow.
But since we just talked about Jane, I think that was very much what a lot of people were sort of feeling like, Diddy might walk free based off of her testimony. Because one of the things that I noticed is that the defense, I was actually looking forward to how they would cross-examine her. I saw immediately they brought up her age. The fact that she was 35 years old when she got with Diddy versus Cassie, who was 19, 20 years old.
Now, mind you, that's it's not an element about domestic violence that you have to be young. As the public and as lay people, we can understand how you are more easily coerced as a 20-year-old versus a 35-year-old mother. But that being said, domestic violence is happening among senior citizens. There's no ceiling for when that type of abuse can stop.
Yeah.
And someone's susceptibility is really, it's individual. So just because we would consider her grown does not make her any less susceptible to his coercion, the financial coercion that he had over her, the physical violence, and sometimes just knowing what Cassie and some of his previous girlfriends went through, that's in the back of your mind.
Yeah.
So that like he could pop off at any moment and maybe you're a little bit more compliant from the outset.
Yeah.
And an abuser knows how to pick their victims. They understand what to look for because not every person is going to be as susceptible as somebody else to the manipulation, to the gaslighting, to the emotional manipulation that ultimately leads to the physical violence. He's going to know how to pick them, whether they're 20, 35, 55, etc. He's going to understand the psychology really of someone he's looking for that's going to tolerate, and I use tolerate loosely, tolerate that type of behavior versus your victims who are or people who are not.
And one of the things that I think that based off of what we've gotten from this case is that Diddy is, and no denying it, a master manipulator.
Absolutely.
And
Absolutely. There was a recap that I was listening to, and they were talking about, is it Rodney who filed a lawsuit against him? And forgive me if I'm getting the name wrong.
Lil Rod.
Yes. And talking about how he used to work out with Diddy, and Diddy would have them watch video clips of TD Jakes together. And not because he wanted the word or inspiration, but he wanted to understand how TD Jakes sort of encaptures people and how he carries himself so that he could use those same techniques to kind of master manipulate the public.
Whoa.
I thought that was interesting. Very, very interesting.
Very interesting. I think we will revisit the Gina of it all, but I don't want to forget all the questions that are buzzing through my mind.
Yes. At the end of the day, just to tie off this point, he's clearly a charismatic person that people were drawn to, whether he was abusive to them or not. And which is also the hallmark of someone who's abusive too. You usually have people saying, oh, not that guy or not that girl. They are so this or that. I would have never expected that from him. But he knows how to turn on the charm, and clearly knows how to turn on and off the violence, tempering whoever he needs to be around. And this is a little tangential point too.
Yeah.
I was curious if the prosecution was going to put on a witness to contextualize the significance of Diddy for this jury. You, and I think your listeners, understand who he was, how larger than life. He was sort of the definition of a mogul. Does every member of the jury understand, A, how wealthy he was and how powerful he was to really understand what it meant to be under that man's thumb? And I don't know if the prosecutor should assume that everybody just knows that off rip.
Yeah. And in fact, you bring that up. I'm like, I don't feel like they brought any witnesses that did that.
I mean, some of it's inherent when you're talking about the wealth, you're seeing the size of his homes, you're hearing about all these businesses, but we also live in a society of smoke and mirrors, and we can't assume because someone looks one way, that's the case. But for all we know about him, the man was extremely wealthy and living a very opulent lifestyle.
The last time that you were here, I don't recall whether or not this had happened. I don't think so. But the judge had to reprimand Diddy for his facial expressions. He reprimanded his defense team for his facial expressions. I want us to talk a little bit about what's going on within the jury, the 14-page motion that was sent over, was it last weekend? Yeah, it was this past weekend. First of all, what was your perspective when you found out that the judge had to reprimand Diddy for his facial expressions towards the jury? And apparently had been doing that since the beginning of the trial, according to journalists within the room.
From a defendant's perspective, that's common. That is your way of communicating without communicating, and sort of silently either co-signing on what people are hearing or showing like some tacit disapproval of it. It's common. It's very common. You often hear judges reprimanding defendants, particularly in front of a jury, but in the courtroom generally, you need to just sit there. But I was in Diddy's shoes. I would also be making eye contact with every juror, over the course of 6 to 8 weeks, even when you're not speaking directly to people, a bond and a kinship can be formed. Think about how much time they've all spent together in that courtroom, even without directly interacting.
Yeah.
And so if I can make eye contact with people on a daily basis, if I can smile at people on a daily basis and kind of build a little silent rapport as a defendant, I'm 100% doing that. So does that surprise me that he did it?
But it's against the rules.
It's completely inappropriate. It is not allowed. It is completely inappropriate. He should have been more subtle, and maybe he wouldn't have gotten caught. But the judge was well within his right to reprimand him and I think scold him firmly. Now, it would be a big step to absent him from the trial. That's usually when someone fully acts out. And by act out, I mean they hit someone, they're hopping up from the table, they're throwing things, they're yelling things. That's when you get removed from your own trial. But the warning had to be stern so that he would cut it out and know that he's serious.
Speaking of him being expressive towards the jury, he was also being expressive in looking at the media outlets that were covering this case, including Stephanie Sue from Rotten Tomatoes. And she says that he spoke to her saying, I know you. And at first she didn't think anything of it. And then he did it again. What is the legal perspective on, is that allowed? Is he able to talk to the media?
You're not supposed to be like, he couldn't turn around and have a full-on conversation, but a judge, and usually, at least in state court, it's the bailiff that says whether or not it's okay to be interacting with the audience. But people's family members will be there. Usually you're allowed to turn around, acknowledge supporters, acknowledge your loved ones, speak a I love you. And he, again, you give him an inch, he's going to take a mile. And now he's talking to random people, again, trying to do that kind of kinship and connection.
Inappropriate. How they cover him, I'm sure.
Exactly. If you were in that courtroom covering it and Diddy turned around and looked at you, throwing up a heart, talking about Esquire, I know you. You might come back on the channel and be like, well, maybe I've been wrong, y'all. I saw his soul, but that's what he's.
I saw the devil. This is another reason why I do not want to be in the courtroom, to be honest with you. I'm very sensitive to energies. I was like, no, I don't want to be there. But I honestly took that as, we have to remember who this is. We know
manipulation. That is so manipulative. It's highly inappropriate. But when I say understandable, I don't mean understandable as it's appropriate, but any of us in those same shoes, to whatever extent we could be a puppet master at our trial, manipulating people and trying to build rapport, I certainly would be doing it. I'd be up in every juror's face, smiling in the whole nine. I do as a prosecutor appropriately, because outside of the courtroom, there is no interaction and we can never speak directly to each other. But inside of the courtroom where the judge is there and other parties, I look at jurors, I sort of tacitly say hello, but that's about the extent that you can do. But
good morning.
You're building rapport. You are absolutely building rapport and trying to gain their respect.
Speaking of building rapport, terrible segue. Kanye West made an appearance last week, even though I heard a report today that he's been at a $170,000 a week mental health thing abroad.
What?
They said he's been there for like a month, but I was like, he was here at the Diddy case for about 30 minutes.
He was at that same facility that Jax Taylor was at from the Valley, where Jax is in there running his own program, still calling and harassing. But I guess when you pay that kind of money, who's going to tell you no? Who's going to check you, boo?
What was your perspective when you heard that Kanye arrived there?
If I were Diddy and his team, quite frankly, I don't want the public Kanye support. Kanye just ended his anti-Semitism era. This is someone
Did he end it?
Allegedly.
Oh, okay.
But I guess he tweeted something like, basically, I'm done being anti-Semitic, for whatever that's worth.
This week.
But the person who was selling swastika t-shirts around the Super Bowl, who trots their wife out naked and barefoot routinely for clicks and clout, who has been banned from European countries for having sex acts performed on them in public, I don't know if that's the person who I want showing up at my trial from a PR perspective,
Yeah.
saying that they have my back.
And then people are speculating because you remember when Jane was testifying, she testified to another popular rapper and his wife in Vegas, and everyone, internet sleuths pieced
Right.
together this was around Bianca's birthday. They also went to Vegas. So people are assuming, we don't know, allegedly, that this other rapper could have been Kanye West. That this rapper could have been Kanye West and Bianca.
Mm.
Part of me thought that Kanye showed up to almost intimidate Jane, not knowing that she wasn't testifying that day because there were already
Right.
rumors that he was going to be showing up, and then he shows up.
Or that you can't saunter into the main courtroom when you feel like it.
10 o'clock?
Sir, people have been in line for hours
Yep.
to get into that packed courtroom. You're not sauntering in when you feel like it. You know what, Kemp, you're right. And it's probably the dual purpose of he can intimidate someone and make some headlines for himself. He's constantly escalating, trying to find a way to be talked about. And so, and it worked but then he realized this can't be about me. And left after what, like 40 minutes?
Yeah. If he was in communication with Diddy, would he still been able to make it into the main court, like with the family?
It seems like there wasn't space for him or a seat saved for him. And given what a tight ship the judge runs, he probably would not have wanted any antics or that kind of distraction by having the likes of a Kanye West walk in while court is in session, a witness being on the stand, being disruptive to the jury. So I would imagine that's why he got sent to the overflow room. And which one of Diddy's sons did they send out to sort of be his escort?
Christian.
Yeah, had Christian escort him around for the time being. It was weird, but you can't put anything past Kanye.
Mm-mm.
But in all seriousness, if I was Diddy's lawyer, it would have been a hard pass. And having Kanye associated at all with you at this stage, he's just too controversial on his own for some of the things that you're being accused of. So
he's been the only celebrity that's been closely associated with Diddy to publicly come out in support of him.
And what does that tell you?
And there are rumors that other celebrities may take the stand in Diddy's defense. I don't know if there's any truth to that, but it will be interesting when they start presenting their case, who exactly they decide to call.
I mean, it probably will be a lot of character type witnesses saying, I never saw him doing X, Y, and Z, or he's a great person, et cetera, et cetera. And that's a yes and for the prosecution. He could have been wonderful to you. Mm-hmm. There's so much evidence about him being a tyrant. And notwithstanding that, everyone still really had a lot of admiration for him, including his ex-girlfriends. No, not a single person has gotten on the stand and said, I hate that man. Not one. And that just speaks to how charismatic and manipulative he really is. That even with some distance, you have people like they liked being in his orbit. They just didn't want to be abused.
Yeah. When Jane was on the stand, there was one particular juror. I saw a lot of journalists reporting. There's one particular juror, a woman, that's very expressive. She does not have a poker face. And when Jane was testifying, they said she was making all kinds of like, oh, here we go. Or anytime that someone mentioned that they were paid by Diddy, she would be very expressive with her face. What is your reaction to that, especially as a prosecutor, that one of the jurors clearly it's not falling for your case at this particular point?
Now, mind you, the jury clocks everything that you're doing as lawyers, and particularly if you have a team, so there is multiple attorneys for both sides in that courtroom, someone is assigned to watch those jurors every single day and to pay attention to how the jurors are responding. So you are taking all of that in. It doesn't change your game plan, but it could mean when I get up and do my closing argument, I know who I need to hone in on because this person might be skeptical of my case, or I know who I feel like is with me. So I'm going to make sure I really have them. So they're back there advocating for my position and reiterating my arguments when they deliberate.
Yeah.
That being said, any trial lawyer will tell you this. You cannot put too much weight on the facial expressions you're getting from a jury. Every single person who has ever done a trial can tell you they've had jurors who seemed like they hated them and they ended up voting their way. Or you've had jurors that you swear are with you. They are nodding. They are tearing up. As prosecutors, they're tearing up at some points during your closing argument. And then they didn't go with you. So facial expressions and reactions in the courtroom do not always tell the whole story, and you cannot hang your hat on them. There is plenty of room to be surprised. And mind you, if the jurors choose not to come forward and identify themselves, we'll never know. And another thing, they talk about the jurors taking notes and being very attentive, and it seems like they are. But I've had cases where it seemed like someone was taking notes, and come to find out their notebook was full of drawings. The notebooks the jurors can't keep them. They're supposed to be destroyed, and we can't look at them. But you can, if they leave them sitting on their seat in the courtroom and you walk by, you can glance down and see, or the bailiff might have seen them like cleaning up in the jury room, and you'll see. Or in one case, we were doing read back, meaning the jurors wanted to rehear the court reporter read testimony of a witness. And so the attorneys get to go back into the deliberation room and actually sit in there during read back. And I could actually see someone's notebook, and it was full of pictures. And what it looked like is they were attentively taking notes the whole time. So again, you're seeing one thing. It does not necessarily mean that's what's happening.
Yeah. And it was interesting because I do want to talk about juror number 6. Because it was interesting when Diddy's defense team were defending him. They were like, he's very attentive. And I wish I could say the same about everyone else. And I was like,
shade about everybody. But then too, there'll be people who it seems like they're asleep, or they've been like this the whole trial, or like eyes closed. And then you talk to them after, and it's like they have a photographic memory and are recalling all kind of stuff. Obviously, you're taking it all in as the attorneys, and you are trying to be responsive to it, but it's not everything, and it does not tell the whole story by any means. But they fought hard for that juror. So clearly, 2 things. You get a vibe, and their vibe might have been, he's with us. Doesn't mean it was true, but that's the vibe they're getting. And second, ripe issue for appeal. A juror being removed, like huge appellate issue. So they've got to be all over it if he's convicted, to have a significant issue on appeal.
So I recall the last time that you were here, you said that they have to make a big deal of these moments because you can't go back when it comes to appeal if you didn't make a big deal about it then.
Correct. If you don't object at the time for certain types of objections, it's forever waived. And so you could not raise it on appeal. And a juror it's not, I won't call it common, but it's not uncommon. It's not as if it never happens that a juror gets removed mid-trial, but it is a very big deal and very, very important for the judge to make a cohesive and thorough record about why they removed that juror. And then the appellate court is likely to be deferential to the judge's reasoning about why they took somebody off and that they had a legitimate reason for it. And the issue of candor, which begs the question of why can't you answer basic questions about where you live? It's giving you're trying to get on this jury.
Yeah.
Which I think the judge said in not so many words that it's suspicious, because it's, even if it was, I was living in the Bronx and then I moved to Jersey 2 weeks ago, we've been here almost 2 months, even that would make sense. But it seems like he could not give a cohesive answer.
Yeah.
And it's troubling. It's very troubling. I would think even from the defense perspective.
That's my first thought, but I get it. Thinking based off of what you've taught us from this, why they made a big deal about it. But at the same time, like, why would you want this person on your case right now, especially if they don't seem trustworthy and they seem inconsistent?
I mean, and just so many thoughts around the tact that the defense team took. And I understand from the outset, you can't make assumptions about any jurors, and you can't make assumption about Black jurors. And the idea that having Black jurors with the Black defendant means that you're going to have somebody who's with you, or that's the only person on that jury that could have like empathized or understood Diddy or where he came from. We're talking about people from 2 completely different walks of life, like a wealthy mogul and then someone who works in corrections. And my mother worked at a prison, so I completely understand that world too. I think Black jurors aren't here for the BS. They don't want no nonsense. type cases, but they will convict somebody in a heartbeat
Mm.
if you prove your case.
Yeah.
So you can't make too many assumptions that way. However, I took a look at the letter that you obtained from Pace. I love that. I love that. That's like
It was
give me
juicy
all the
read too. I mean, I think that they really had a valid arguments. I was like, oh, I didn't think about it that way.
and it is pulled straight from what's happening in California.
Oh,
Almost all of the reasons that the defense mentioned that the prosecution excluded jurors during jury selection during the voir dire process
mhm.
are now presumptively invalid reasons in California state court. I could not kick someone off my panel because they said they had a bad experience with the police, or that they're anti-law enforcement, or that their cousin, mother, whomever was convicted of a felony and is currently in prison, and therefore I don't trust the system. In California, none of those are valid reasons to remove someone.
Wow.
So the federal courts haven't quite gotten there, but the courts are really moving more towards equity in jury selection. I mean, it's a conversation for another day. They are overcompensating, I think, but they want race neutral preemptory challenges to be made. And now you're not allowed to kick somebody for race to begin with, but prosecutors all over the country have been accused of using the very wide latitude we have of kicking people to kick off Black and brown people off jurors, and then have what you could argue is a legitimate reason to do it. And a lot of those reasons in California have been taken away in an effort to make sure that Black and brown people are not automatically being kicked off. So the defense is pulling from a playbook that has been effective in other states. So I understand why they were making those arguments. And if the Southern District of New York and the Second Circuit, which is the appellate court, is kind of moving in that direction, the defense has given them something to sink their teeth into, which is why the judge's record about why he removed the juror is really, really important. California has taken it so far that if I get a conviction and the appellate court is reviewing my case, which on a murder, for example, happens automatically, without the appellate attorney even raising an issue about the jury selection, the appellate court can on its own, that's called sua sponte, on its own, reverse my conviction if they feel like something inappropriate happened with jury selection, or even with a juror throughout the trial. That is like a massive, massive deal. So the defense is going to jump all over this and hope that maybe they can even make some new law in that federal circuit as it relates to removing jurors.
And what is your perspective on how the judge handled it?
It seems appropriate. He was not quick to make a decision. He inquired of the juror. It sounds like the juror said something in passing to, usually it's the bailiff or someone from the court staff that's kind of responsible to corral the jury and move them from place to place and come get them from their breaks. Sounds like he said something in passing to a member of the court staff that just wasn't jiving. And then the court staff probably brought that to the judge's attention. And then it's common practice for the judge to bring the juror in by themselves outside the presence of everyone else in a closed court with just the parties and the defendant and inquire of that juror. And it sounds like the judge did that, was not satisfied with the inquiry, but still gave the defense an opportunity to raise objections, but then ultimately landed how he did based on that inquiry. It wasn't a tough call for the judge, but it's a novel area. So it makes sense for the defense to have exploited this and to have made a huge deal out of it.
Their third attempt to move for a mistrial.
Yep.
Can you remind the audience why they're doing that again?
Yes, you want to make your objections at the time so that you can raise the issue on appeal. If you were to get a mistrial, it does not mean Diddy walks. It means they stop these proceedings, they dismiss the jury, and then they start all over again.
Like the candor trial.
Exactly. And then who knows, maybe it ends up in an acquittal. But so that jury hung, the judge declared a mistrial. the defense is going to make a motion to dismiss the case. But if it's a close hang, meaning that at least 6 people voted for guilt, sometimes a little less, or at least half of the jury voted for guilt, not necessarily put a number on it, but just to give an idea, the judge is not going to dismiss the case. And mind you, the judge heard all the evidence too. And while the jury is the finder of facts, the judge can say, I heard the case that the prosecution put on, and I think if we did this again, there's a reasonable chance they could get a conviction based on the evidence they have. Or in a rare case, the judge can say, I heard your case, and I don't think you're likely to get a conviction based on this evidence. I am going to go ahead and dismiss it.
Oh, oof.
Because I don't think as prosecutors or the government that you can do anything different or you can do anything better. If you present the same evidence all over again, it's likely to be the same outcome. So they'll grant that motion to dismiss.
And if that were an issue that came up, would the defense have to ask the judge to make a decision on that? Because if it was
Yes, if the judge declared a mistrial, the defense would absolutely then ask for the case be dismissed. Based on everything we've heard come out, I think it's unlikely the judge would dismiss the case.
Yeah.
And so likely they would hit the reset and in a couple of months be doing this whole thing all over again.
A couple of months?
Yeah, it can go fast. It can go fast. And he's trying to get out of custody. Like,
okay, so if let's say a mistrial does happen, can he attempt to get bail again? I
yes,
asked that question the other day to myself. Oh, he can?
he could, because it's a change in circumstances, but it's unlikely because the judge has heard the evidence. And it's possible, but it's unlikely that he'd be granted bail.
So all of these attempts, in which we talked about during the last time that you were here, Kirsten, all of these attempts for a mistrial, you're saying that you see that as something for the future when it comes time to appeal.
Correct. I mean, they haven't raised one that seemed like it was even a close call, but you have to raise it. You want the judge to rule on it and to give an opinion, and then it's going to be a big appellate issue potentially later.
That's not the only juror issue that came up this week.
I know.
There's another juror that possibly may have spoken to a colleague about this case, and they're not supposed to do that. Absolutely.
Big no.
There has not been a decision on what to do with him or her. I think it was a him, though.
And I think the judge is not trying to rush to judgment because the alternates are hearing all of this too. So if you're taking off people that are a part of this, we call it the sworn panel, and substituting an alternate, there's no rush to do that because they're still hearing everything. So if the judge wants to take things under submission, perhaps do another evidentiary hearing, hear more from this juror about what's going on, but they're admonished every day, probably every single time they leave the courtroom, even for a break, to not discuss this case with other people. And if there's evidence that they have been, that juror is getting removed and the alternate's going to be subbed in. And it's so interesting how that could change the vibe because the jurors have been in this together for weeks and they're not told why someone gets removed. So they'll just find out that person isn't on the panel anymore and the alternate is in, and they're not given any reasons why.
We know more than they do at this point.
We know more than they do. They're not told. So now they're just speculating. And if it's someone who was popular among the jury that they liked, it's like they're serious. They're still going to do their job, but it can shift the vibe for sure. But I'm sure the alternates are like, hell yeah, like get me off the bench and into the big leagues. I want to participate. And I've been hearing all of this evidence too. Being an alternate's the worst. You hear all of it and then you don't get to make a decision. So
wow.
And I know too that there's been speculation about the prosecution trying to get this person off on purpose so that they could kick a Black juror off mid-trial. Highly unlikely because of the appellate issue that it's creating. And so if they convict Diddy, you don't want to be the reason why your case is getting overturned because you did something nefarious as a prosecutor with the end run around trying to kick Black people off the jury 6 weeks in. So it seems highly unlikely it's a prosecution ploy. And you don't pick who comes in next. The jurors are put in order and assigned a number. And so either the next number is up or they draw at random.
Okay, I was going to ask
So
you this too. So,
yeah, they don't have any control over what alternate comes onto the panel.
and what we do know is that a white male was the next one in line.
Right. And I've heard two different job descriptions. I heard he was some type of engineer, which we talked before, red flag for me. But then I also heard architect. So I'm curious what his profession is. And then again, you can't assume because he's an older white male that he's going to hop on and be super pro prosecution. Just can't make those assumptions about people.
He probably loved 90s R&B too.
He probably did. And he's also of the generation where he might be like, what is all this like consent and coercion? And like, why didn't she just leave? I don't know. Obviously, I don't know this person, but there's different. The way we talk about abuse now is very different than they were 10, 15, 20 years ago. And so he could be very much of this generation that's like, what's Me Too? What are we talking about here?
Or over it too.
And over it. Yeah.
Oof. All right. Moving on from there, in regards to some of the other testimony this week, we got to see that rewinding back a little bit though, for those that may have missed it, I did read through the 14 pages if you want, because it actually is pretty juicy in regards to
very well written, very interesting.
I thought the defense had some valid points. They almost got me going, maybe they're right. It's a prosecution racist, but no.
These were the arguments happening in California State Court a couple of years ago, and it led to a change in the law. So they're legitimate arguments. Wow. I mean, at the end of the day, we want a fair and unbiased jury.
Yeah.
And a jury of your peers doesn't necessarily mean that it'll have anyone with the same racial makeup of you. Your peers means the community of where they come from. But it is highly inappropriate. And there's evidence of prosecutors deliberately kicking people of color to not involve them with the process. So we don't want this trial to be made an example of because it's so consequential. But as prosecutors, you know what you can and can't do. Don't play games with this kind of stuff and put your convictions at risk. Like play it straight.
Yeah.
Follow the rules.
Some of the other things that they posted in this 14-page love letter to the judge included some of what they were already mentioning in regards to the last time that they asked for a mistrial, and that was Brianna's testimony, who worked with
the perjury.
Yeah, with Cassie, accusing them of lying on the stand, both Cassie and Brianna lying on the stand. And they brought that up again in this. So they brought up a few things, and I was like, well, this is interesting. And of course, the internet streets were speculating, oh, did he plan to this person? This is why they're fighting hard. But like you said, layman's don't understand what people could be doing legally for the future of this case.
Right.
In regards to this is why we love that you're here teaching us all.
In planting, you can't rule anything out, especially when you're talking about somebody with resources. But there's a lot that's under no control, including who gets a jury summons to begin with. And I think 600 people initially showed up to do those initial questionnaires. And then from that 600, you get down to a total of 18, 12 in the box, and then 6 alternates. And statistically, how does it work out that your plant ends up on the jury? But you do get a list of prospective jurors and names. And again, when you have such a big defense team, I'm sure it was someone's job to run through that entire list, check their socials, get on the internet and find out as much as you can. And I think there was a movie, I can't remember what it was called, but it was about jury tampering. It's probably 20, 25 years ago, but it was the defendant getting to the jurors and paying people off systematically. The name will come to me in a minute. So it's not impossible. It's highly unlikely.
Yeah. I honestly, I said this in my coverage of it, I said 1% of me believes that because I see what he's capable of.
Right.
But I was like, I don't know if that's what, especially I think based off the conversation we had the last time, I think that really did change my perspective on what could be happening here. And hopefully we're doing that for our audience as well.
Yeah, that is obviously illegal and a bold move. Yeah. But hey, this man had one of his assistants in an empty warehouse hooked up to a lie detector.
And now victim number 3 is not testifying.
Yeah.
I think that was one of the prosecution's witness that they've now decided not to include, which is interesting.
Very interesting.
I think if I'm Correct. I believe they mentioned the fact that she wasn't testifying in their 14-page letter.
Did
I think so. I can't remember now because
I can't recall seeing that
it's a
either.
lot. 14 pages.
But that's also not a reason to ask for a mistrial. And if the defense had been talking or communicating with her, I wouldn't highlight the fact that she's not testifying and that they know that definitively.
Brandon Paul,
the drug mule.
Yeah, I wasn't gonna call him. But, I mean, they're labeling him as the personal assistant. He still has not taken the stand officially. He did take the stand to plead the fifth and get immunity,
right?
Which he was granted. I mean, again, is this just going to be another personal assistant confirming? I mean, this is a recent personal assistant,
right?
Confirming what for us from the prosecution's perspective?
It sounds like obtaining drugs and distributing them, and maybe even flying some of those drugs across state lines. And the immunity in all this drug transactions would be enough in of itself to get a grant of immunity. But it also seems like they've established that he was procuring drugs, giving out drugs, his Gucci pouch, like that's all of that is in evidence. So I wonder if there's a little more to get from him besides that.
I'm actually really looking
the prosecution wants to end strong. You want to start strong and you want to end strong with a really good witness to close out your case with. And while all of these summary witnesses are getting a lot in evidence for them, that's not going out with a bang, if you will. Maybe he will have something to say beyond the drugs that kind of like closes their case as strong as their case started. Because with Cassie, it was so literal pearl clutching testimony for days. And you want to end that strong too. So have high hopes for this witness, but I don't know.
And this is one of the witnesses, for lack of better words, looking forward to the testimony because I didn't expect him to testify. I really thought if they're going to close out this prosecution's case, I thought it would end with the ultimate personal assistant, AK.
Yeah.
I don't understand. I don't understand this.
I guess they figure the text messages that they were able to get in through these summary witnesses that include some of KK is enough for them. And I mean, and technically it is.
Okay.
But she's been mentioned so much. As a prosecutor, you don't want the jury to have any questions in their mind about, well, what might this person say? Or where's that person? And there's jury instructions that say you don't have to call every available witness as either the prosecution or the defense if you choose to put on a case. But you don't want your jury to be back in the jury room deliberating and speculating on what someone might have said or how they could have contributed. If they have those kinds of questions, as a prosecutor, you were deficient in your case, and that doesn't bode well. That's where doubt starts to creep in.
With all of these text messages that they were reading, that's hard to determine tone. That's hard to determine intention.
Right. And like the defense did, because they entered so many of them. And then so you've left the door open for the defense to say, well, you're cherry picking these texts and not showing like the whole breadth of the conversations. However, when the text is like, you gave me a black eye, I don't want to do this anymore. What other context do you need?
I don't need any other one, but apparently the world does. Because if you saw the comment section of the internet, it's just like, oh, because even with Jane's testimony, people doxing her. Oh, wait, before I even move on to Jane, because I've been meaning to ask you this. The judge really admonished both the defense and the prosecution for information that was leaked online. What was your thoughts on that? Because I was like, because I don't know what exactly the article pertained to or what evidence was.
Nobody does. Nobody. Did the judge get the argument like taken off the internet? Because no one.
I think he is on the internet streets. You remember he was to Mark Garagos's podcast.
He might be watching right now.
Okay, sidebar. I'll decide whether or not I'm going to keep this in. I think I saw him in the streets. I mean, I'm in New York, so it's very possible.
There's like paparazzi footage of him in his like orange puffer coat, headphones on, strolling up and down the street like going to a bodega and to grab a coffee.
I
Sir,
mean, you're a
where's your
regular person, but now
protection?
you're a star.
I know.
But I
Taking this,
could have
but
sworn I
you know
ran into
what,
him, and he
Judge?
kind of looked at me, and I was like,
Oh, maybe you did.
I don't know. I don't know. But anyway, I say all that to say we have some questions from our audience because I've held you up long enough and you have your own cases to deal with.
I know, but tomorrow's a court holiday.
Oh, thank
So,
God for
so
now.
I have tomorrow to work too. It's okay.
Okay. All right. So, okay, we have quite a few questions from our members. Shout out to our members. We appreciate you guys so much. We made this exclusive to our members. So I'm going to jump around because I see K-Dub has a lot of questions and some
Okay.
good questions. So I'm going to
Hey,
jump.
you have smart listeners who
Yeah.
are like
Oh, I love
dialed
those.
in and like asking like the real questions.
Yes.
The real questions.
Not the shady, juicy one. No. Okay. Tamara from Queens, New York says, if he's convicted of federal charges, can the state go after him for the same charges without violating double jeopardy?
If there's any state charges that have not expired by the statute of limitations, yes, they can. Because state charges and federal charges are two different systems. So it's not double jeopardy to be charged in both. If you remember the Derek Chauvin case, who was accused of murdering George Floyd, he faced both state charges as well as federal charges for those crimes.
Okay. So that makes sense. And then when you think about Jane's testimony, Jane dated him up until he was arrested.
Right. So there's a possibility of some state DV charges because those statute of limitations are usually around 5 years. A little bit longer if there are sex crimes, but for DV, it's usually about 5 years.
And it varies state to state?
It does vary state to state. But New York and California are two jurisdictions that expanded the statute of limitations, which is how we've seen a lot of prominent people, Diddy included, coming to trial in recent years.
Okay. All right. I'm skipping around, everyone. All right. Let me get to K-Dub because K-Dub has a lot of questions and we appreciate it, K-Dub. So please understand, I don't say that in a shady way. So this is Kimberly, and she lives in the DMV. So she hear my questions. Sorry in advance. I have a lot of questions. It's completely fine. This is what it's for.
Yeah, let's talk about it.
Can you explain the legal basis for dismissing juror number 6?
Sure. Juror number 6 was dismissed for a lack of candor. First and foremost, you have to live within the jurisdiction of where you've been called to serve in a jury. A federal jurisdiction is going to be broader than a state jurisdiction because they're going to be pulling from the entire Second Circuit, that federal circuit. So it can include a broader range of geographic areas, but apparently it does not include New Jersey. So if he does not live within the geographical area of that federal circuit, he is presumptively not qualified. I should say, what word am I looking for? Presumptively ineligible to be a juror in an SDNY case. So off rip, that's one. The second one is where you live are pretty basic questions to answer, even if that changes. And so
I'm sorry to interrupt. And also, is it a fiance or a girlfriend? And
he said both.
See, this is what
he said. And so, because at first it was like, I live with my fiance and my child's mother in the Bronx. But then it was like, I have a girlfriend in Jersey. And maybe that's the issue. Maybe he has both. And he just got found out. I mean, but, you know, Kemp, if a judge calls you in, and even if you're nervous and they say, where do you live? You should be able to answer that question. Even if you just moved, even if you stay multiple places, you could say, hey, I stay with my parents 3 nights a week in Connecticut, and then 4 nights a week I'm in the Bronx. But you should be able to be forthcoming about that. So it was raising a lot of red flags when his answers were inconsistent.
But he had a New York State ID.
I mean, he at some point could have lived in the area and subsequently moved. I mean, really, the question is unanswered, but that's the problem. The question is unanswered. You need to be able to give the court a straight answer about where you live.
You low down dirty dog, juror number 6.
Yeah, and you, like I said, it's giving, I'm trying to get on this jury and we don't know what reason that would be.
Yeah.
Either he has an agenda and wanted to vote one way or the other, or he thought he could monetize it after the fact. We don't know. But
I mean, he could still write a book, Juror number 6.
he sure could. He sure could. He was there for most of it. So,
Yes.
and now he's probably consuming a lot more information. We're assuming he was following the judge's rules that he wasn't privy to. If he was not consuming media or talking to people per the rules, his mind is probably blown right now with what's out here about this trial.
Damn. Juror number 6, heads up, write the book. Juror number 6.
Write the book or come on this podcast.
I don't know if I want to talk to
Kempire Esquire get the exclusive.
I mean, honestly, yes, I'll do it. You know why? I need to
For the
know.
people.
Were you cheating on your fiance? Which one was it?
How old is the baby? The alleged
Where do you
baby.
live? And why were you why did you lack candor?
Yeah. So there was a legal basis.
That's with his title. Juror number 6, why I lacked candor.
That's it. That's it.
All right. I don't want to keep you because we have a few more questions from our girl, Kimberly, and they're great questions. Which predicate, there we go, acts do you see as the strongest example of racketeering activity?
You know, it's interesting because there's a lot of predicate acts, but they're singular. For example, the Molotov cocktail in Kid Cudi's car, significant but singular event. The extortion of Cassie's mom, significant but singular event. If we believe that he was dangling someone off of a balcony, significant but singular event. But the course of what he was doing with Cassie obviously happened over years, and then he seemed to pick that behavior right back up with subsequent girlfriends up until the point that he was arrested. And I don't want to go too like legal nerd on you, and I haven't done this research, so I'm not sure yet, but the judge can give what's called a unanimity instruction. And there's sometimes where there's predicate acts where the jury has to agree on what all of the conduct is that makes up the crime. Sometimes the jury doesn't. So you can give them 10 different options of what the predicates were, and each juror could say, I believe 1, 2, and 3, but not 4, 5, and 6. And another juror says, I believe all of them. And another juror says, I only believe 2 of them, and they don't have to agree on what the predicate acts are. What I need to do some research on is, does the jury have to agree on what the predicate acts are and reach a unanimous decision about that? Because that's a lot more challenging than throwing out all of these options and letting people pick and choose what resonated with them based on the evidence.
And the jury instructions, those will be made public, right?
They should be. It's literally, they say like legal pundits, that cases are won and lost with jury selection. Very important. The other part is evidentiary rulings, meaning what gets excluded or allowed to be entered into evidence. And the third one is jury instructions, because the defense will be asking for certain instructions to be given. The prosecution will be asking for certain instructions to be given. Each side will ask for certain instructions not to be given. And then the judge puts together the legal basis for the packet of instructions that's read to the jury. And it can make or break your case depending on what those instructions are. So it's very, very important. Very important. Like, again, just another example. If you are charged with murder and you're arguing self-defense, but you never put in, as a defendant, you never put any evidence on of self-defense, you're not getting that instruction. So that means the jury can't consider it. It's out. So the instructions are very important.
And I think what you said earlier too, because there are no cameras, there's no audio, a lot of people that are already running around saying, oh, the defense has proven their case, Diddy's going to go free. It's hard to make that determination, especially because we don't know what those final instructions will be for the jury.
And the first real indication we'll get about the direction this jury is going in, similar to the Karen Reed trial, once they start deliberating, if they start asking questions. And the questions are very instructive, most cases, to how people are considering. The Karen Reed questions from Monday indicated that they were going not guilty. that they were at least going to be not guilty on 2 counts and maybe hang on an additional one. So that's going to be something that's really important to watch for once they start to deliberate. And jurors almost always have questions because the jury instructions, the law, that's what it is. Those elements of the offense are confusing. And the jury instructions define terms, and sometimes those terms are different than everyday knowledge. And they give you guidance on how to evaluate the evidence, like how you decide whether or not someone's credible. They're going to give guidance on how to evaluate, was it Dr. Hughes, the prosecution expert about domestic violence? Or she couldn't use coercive control. It's intimate partner violence and its effects. How they can evaluate that kind of testimony. So those instructions literally lay it out for how the jury has to analyze the case, but it's confusing. It can be very confusing. It's up to the prosecution to make it clear. Confusion goes to the defense. They want to fuck it up. Chaos. None of this makes sense. Just let them go. The prosecution needs to make it clear, like crystal clear. Element 1, these facts. Element 2, these facts. Element 3, these facts. He's guilty. Like they have to be that clear.
A few years ago, it's been probably even more than a few years ago, I did a focus group where it seemed like they set us up like a jury. What do you think that is from? Were they setting this up? Was it like maybe a defense?
Probably, Diddy's team probably did it. You get jury consultants and you basically get a mock jury.
I hate it, by the way.
But it's so instructive. You can workshop your defense and you start to find out what resonates with people and you find out what doesn't work. Like the public does not want to hear this, but this caught their attention. So we're going to go this way. And you start to develop who your ideal juror would be. So they come to court knowing these are the types of jurors we want. This is how many women we want. This is how many men. These are professions. We're looking for these type of answers to the questions we ask, and that's going to make up the ideal juror. Because the ideal juror is different for every defendant. The same jury that Karen Reed had is not going to be the same for Diddy. And for Luigi, who's also accused of murder in New York. And Mark Agnifilo is Diddy's attorney, and I believe his wife is Luigi's attorney. 2 completely different kind of jury panels, you know? And so when you have resources like Diddy does or a GoFundMe like Luigi does, you want those jury consultants with a mock jury to workshop your defenses. Extraordinarily helpful.
That was the longest day of my life that it stuck out. Literally talking about this over the last few days. I was like, wait a minute, I did a focus group years ago.
And they're not going to tell you because you want genuine reactions and opinions to how someo's responding to what you're telling them. Interesting that you got called in for that. Did you get paid?
Say it again?
Did you get paid?
Yes, it was a focus group. I don't remember how much I got paid, but it was good.
Hey, those little focus groups, sometimes they could be a couple $100. You want me to give you my opinion?
It was all day. I've done a few focus groups over the years. I haven't done one in a few years, but back then I did a lot. You know, we got to make money. Come on.
Absolutely.
But I remember that one I hated because it was it was intense. It was all day. And because I was talking about the jury instructions, I was like, they gave us jury instructions. And I was like, this is a lot.
It's literally, I should have brought something from my office with me. It's literally a thick packet. I mean, we're talking sometimes dozens of pages, and each juror will get their own packet and the judge has to read it to them and they can read it to themselves. And if the judge pre-instructs, they do that before the parties argue. And if the judge post-instructs, then the parties will give their closing arguments and then the judge will read instructions. I prefer to get the instructions first because I always reference them in my closing argument, pull out the packet and say, everyone turn to page 3, instruction such and such. Let's talk about this. This is how you evaluate the evidence for this particular charge.
So they receive their instructions before you do closing arguments.
Yes.
Okay.
Because it helps contextualize the closing arguments that you're hearing.
Okay. All right. I'm going to continue with Kimberly's question. She has quite a few.
Okay.
Kimberly, we love it. We love it.
We sure do. All night, Kimberly.
Yeah.
I can do this all night.
Don't tempt them with a good time.
I know. I'm such a legal nerd. I think this stuff.
But I love it. I feel like myself and the audience have learned so much for you explaining, especially from the prosecution side, especially because this is their case. It's educated a lot of us and a lot of people. I think for those that are watching this one, if you have not watched the first one, please go back and watch the first one because there's a lot of the
I'm happy to
beginning
hear
stuff
it.
that we talked about, a lot of jury selection stuff that we talked about. Kimberly also asked this. She says, how does the prosecution decide which witnesses to grant immunity or protective anonymity?
If a witness could be prosecuted or committed a crime as part of whatever their test, let me back up. If their testimony includes them discussing that they committed a crime, you don't want that person taking the fifth. So then they're granted immunity. Because if they take the fifth, then they're not available because everyone has a right to not incriminate themselves. So if someone has committed a crime, which makes sense in a criminal enterprise of people who were working together or for Diddy to commit crimes, to give them that immunity offer in order to secure their cooperation. However, there's some cases where it's highly unlikely that someone would actually ever be prosecuted for whatever it is they're testifying about. But if they have a lawyer in an abundance of caution, they're going to want to get that immunity agreement. And interestingly, as Kemp, you've noted that the immunity happens outside the presence of the jury. And that's when someone is going to accept their immunity and then testify. If someone is going to continue to plead the fifth or not accept their immunity and not testify, that's actually done in front of the jury, because I can now argue that you can make inferences from the fact that they took the fifth and didn't want to answer questions. So it's a strategic thing too. But the defense often uses a witness being granted immunity as a method of impeachment, meaning to impugn their credibility. So if you don't have to give somebody immunity, you don't want to, because you don't want to create a reason for them to get impeached.
Oh, all right. Kimberly, we'll come back to your questions. I just wanted to see what everyone else had to ask. Okay, so Blanche says, okay, got a couple of questions about KK. Maybe we've answered it. KK, they say KK is listed as a co-conspirator, unindicted co-conspirator. I'm assuming that her indictment depends on the verdict in Diddy's trial. If he's convicted, will they move forward with an indictment? But if Diddy is acquitted, is it likely the prosecutors will proceed with prosecuting KK as well?
That's a very good question. And I think Diddy's conviction or acquittal does not technically bear on whether or not they can indict KK, but it would be instructive. If they couldn't convict sort of the head of the organization chart in this conspiracy, what is the likelihood that you can convict someone below him? So I think if he were to be acquitted, I don't know that you would set yourself up for, as a prosecution team, to charge somebody else within the conspiracy and hope for a better outcome, especially when we don't have any evidence of her being violent. Like, we don't have a video of her beating and dragging somebody like we do for Diddy. If he is convicted, that might make the prosecution feel more confident about indicting her as well. And this is why it would be so helpful to have her testify. Like, were you on board with all of this? Or were you suffering from Stockholm syndrome and just kind of going along to get along and hope that you didn't get caught in the hairs and catch a beating? We don't know, though. We don't know if she was complicit in all of this, or if she, as some people alluded to, was kind of trying to soften some of the blows and be a little bit protective of some of his girlfriends who we know were catching the brunt of it. So, but we won't know that without, hearing from her. She has a story to tell, and I wonder if one day she'll tell it.
If it means a check, probably.
She don't have a job no more, so.
Yeah, and at this particular point, I don't think anyone would want to even work with her.
But maybe is her rent getting paid? Like is it Jane's rent still getting paid?
Jane's rent is still getting paid.
And he's paying for her attorney.
Yes. What does that say to a jury?
Major manipulation. And I'm curious, like, what made you And it sounded like Tinny Garagos was like, we know each other. You were going to be a defense witness. So when did it turn? And it doesn't, at least we didn't get reporting about them diving into that. Like, when did you decide you weren't going to testify for him and instead you wanted to tell what happened to you? Very, very, very interesting tidbits.
Yeah. And again, I don't know if that made her a strong witness, but okay. All right. All right. Let's continue with some of Kimberly's questions here. And Foxy, I see that you asked a similar question in regards to KK, but I think we answered that. In regards to in a trial this long and detailed, how do you keep jurors engaged and focus on the overall narrative? That's a great question.
It's very hard. It's been a long time and you get mentally exhausted. The human capacity to pay attention and absorb information is, only so much. One of the ways you try to do that is by moderating your witnesses based on, for lack of a better word, the salaciousness of their testimony. And you have a really good witness, it's going to capture everybody's attention. And then right after that person, maybe you put a less exciting witness. And then you put a really good witness on again. And so you kind of can create this roller coaster of the way they're receiving information to help drive engagement over the course of weeks.
So that's interesting that the drug mule is going to be, I think, their last witness, right?
It sounds like it. Yeah.
So it's interesting that he would be the last one. So that's why I'm going to pay attention to his testimony, because
And see if there's more.
Yeah. Is he going to tell us something that none of the other personal assistants have said?
Right. And it's everything. I don't want to use the word redundant, but it's building on top of each other. Yeah. And we're starting to hear a lot of the same things, but that's good because you're showing the more you're hearing about these things happening, the more it's sinking in. But it feels like it's been a while since we've heard something new.
Yeah.
That no one else has set up until this point.
Yeah. Okay. She has quite a few more questions if you have some time.
No problem.
Which we appreciate, Kimberly. And shout out to everyone that sent in questions. Do you think individuals who allegedly help facilitate the freak-offs or other coordinated activities, hotel nights, will be held legally accountable either during or after this trial?
Well, a lot of them have been given immunity already, so they can't be prosecuted. If they have an immunity agreement, then no, there'll be no legal accountability. And then too, for like some of the personal assistants who you'd put lower on the org chart, I don't know if that's who you want to go after, like the person who was really excited to get into the organization and work for Diddy. And who's the one who he testified early on and had witnessed the apples being thrown.
Oh, yes.
Awesome. And then ended up lying about his grandfather being sick and saying, I just couldn't do it anymore. Like, is that really the person who you want to have just as culpable as Diddy or be criminally prosecuting? That doesn't feel right. Like, he was executing what he was told to do for better or worse. And then when it got to be too much, he was like, you know what? You're not paying me enough. I'm out.
What about civilly in regards to some of these accusations that are coming out during this trial? Civilly, I know Diddy's facing multiple civil lawsuits, but some not necessarily the personal assistants. And again, you go after the people that have the money.
That's what I was going to say. Practically speaking, it does not make sense. And no lawyer is likely going to take a case of an individual that's not attached to some money somewhere.
KK, I don't know how much KK made, but she was chief of staff. She worked for 10 plus years.
And this is the business side of it. A civil attorney is going to do like an asset search. They're going to have an understanding of someone's capability of being able to pay a large judgment before you ever even file a lawsuit, because it's expensive and it's time consuming. And so you're not going to sue somebody who ultimately can't pay you, which is why you almost always want to attach a corporation like Combs Enterprises or a very wealthy individual.
I.e. what we just saw with Tyler Perry being sued. It's not just Tyler Perry, but Tyler Perry Studios.
Correct, because Tyler Perry Studios is going to be the solvent one where you get your money from, and they even have insurance policies to pay out something like this.
$260 million. That's a whole other case for you to talk about.
Yeah, that's a lot. But I know next pod, that's what you'll be covering next.
Oh, God. I mean, if it makes it to trial.
Right. Right. If it even makes it past summary judgment.
I just found out that Christian Keys, who's mentioned in Tyler Perry's lawsuit, has me blocked.
Why?
I have no idea. Unless it's the recent story, because I did a recent like short form video talking about how he is mentioned in the lawsuit. But you're mentioned in the lawsuit, sir. I'm just doing my job.
And what, practically speaking, what does blocking you do? Is it just to send a message?
I don't know. Unless someone tagged him in the comments, I would have to go look. But I thought that was so random because I was like, let me go, Christian. I was like, I wanted to see if he still had the video that he posted on social media. Where I was defending him. I was like, Christian, go ahead. Tell your truth. I went to his page today because I don't follow these people. I went to his page today to go see if the video is still posted because there are accusations that possibly he got some sort of settlement from Tyler Perry. But he never said it was Tyler Perry. And I've said that. He's never said it. And I said, that's strange. It's the same kind of profile I can't find when I'm trying to look for Portia. So I said, let me go log out and then go look. I was like,
Portia Williams from Atlanta?
Got me blocked.
She blocked you too?
Well, she unblocked me and then blocked me again this season.
Oh.
I take no offense to it because, again, I know I didn't do anything to you besides do my job. And I'm not tagging you. I'm not in your comments.
I was going to say that means that you were reporting some real tea. And I guess to defend against it, Kemp, you were out here controversial on these internet.
I'm going to make a chart. All the people that I know of that I'm blocked by. I'm also blocked by Anita Baker.
What? But isn't she petty though? Huh? Who was she on tour with? Maxwell?
Oh, Babyface.
Oh, okay.
And she did Babyface dirty. So I was Babyface.
That's right. Yeah, because that tour broke up before I had a chance to see it in LA. I was excited. That's random though. Oh, you were out here just
it's okay,
controversial.
It's okay, Christian. He probably didn't want to be reminded that he took a settlement, allegedly. I don't know. That was never, of course, when you take a settlement, you can't talk about it. But it's okay.
That's true. That's true.
All right. Back to the Diddy of it all. We needed that little bit of a break from the Diddy of it all. Let me see what else she asked here. Okay. What do you believe the defense needs to accomplish in the final weeks of the trial to sway the jury or create reasonable doubt, particularly in light of the volume of witness testimony and video evidence? We saw this week they were showed a Freakoff tape.
Right. I think, this is just my opinion, the smart thing for the defense to do would be to make some concessions. And you don't do that with your case and witnesses. It would be their closing argument. But you want to concede to maybe the prostitution across state lines. Something that is, as it relates to these charges, more minor, does not carry a ton of custody time hanging over his head, if he'd even be sent to prison at all on that charge, because you are kind of creating a permission structure for the jury to hold him accountable for something, because we heard so much. I mean, this is a toxic person, regardless of how this plays out. Like, he is a toxic person. So he's being held accountable for something, but you're brushing aside the more significant charges with that permission structure of find him guilty of this, because other things were consensual and belong in state court. And you do something to the effect of, you don't have to like my client. In fact, I don't like my client. We don't like what he did. And if we I mean, like not that dramatic, but say if we were across the street in the state courthouse, I'd be the first person convicting him of domestic violence. But that's not what's happening here. That's not what he's charged with here. And then you go through and methodically, just like they did on cross-examination, start poking holes in some of the testimony and the credibility issues raised by some of these witnesses. But the volume of people makes it very hard to say everybody's lying. What gets, and especially because no one hates him or seems like they're out here with a vendetta. Like they just want some accountability, or they were forced to be here, which is true of some of the people. I got a subpoena and I was told I need to show up or I'd be held in contempt.
Part of why I don't understand how a KK or a D-Rock, who's been mentioned multiple times, has not testified.
I don't either. I
don't. Interesting to see the witnesses that the defense calls.
Say that again.
It'll be interesting to see the witnesses that the defense calls.
Yeah, and there's if they're just going to put people on the stand to say no, he's actually a nice person, that is a waste of it's a waste of time. So I'm curious to see if they've got some substantive witnesses to actually poke holes in the prosecution's case, like the elements of the crime. That's what you have to focus on. We talked about the first time I was on how there's essentially ingredients that make up each charge. And if just one of those ingredients are missing, it's a not guilty. And so they want to strategically poke holes in some of those ingredients to get an overall not guilty or acquittal or conviction on a lesser charge.
Okay. Ooh. Okay. I have my own question.
Sure.
If you were the defense, I know you're a prosecutor, but if you were the defense, who would you call, or would you not call anyone?
They had was it CFO on?
Yes.
I would probably want some people like that that might be able to separate the organization and my business and my finances with the organization through personal money and maybe start to create that divide. So his capacity of these Freakoffs and King Nights and in the Gucci pouch and all of that is separate and apart from his business, and sort of emphasize the legitimate businesses that he was running for decades and separate that from his personal life.
Didn't they find out this week, though, that Diddy at some particular point did pay for the sex
Sure
work?
Did. That's why it's going to be a problem. Up to $1 million. $1 million Amex bill that you had your accountants within the organization paying. I mean, these weren't sexy witnesses that the prosecution put on at the end, but they brought out a lot. They have a lot of cell phone evidence, the corporate receipts, getting reimbursement for buying drugs. Like, can you just get a petty cash account? Why do you have people filling out a reimbursement form to buy Molly? Can you just have some cash at the house? What is going on? In the text about Guido's here.
Well, here's the thing.
Someone go take care of Guido. Texting, can I pay Guido? Approved? What?
I think he just got sloppy in the end. You're doing that amount of drugs. There's no way you're thinking about the legal liability of any of this.
You clearly aren't. Like, don't talk to me on my company cell phone about Guido's here with the pink flower. Like, and it almost must be like, KK, like, why wasn't somebody like, why don't we just keep some cash? We're just gonna have a petty cash drawer, and this is where we're gonna pull from to pay Guido and the others, rather than run it up through the accounting department.
But I get your perspective in regards
credit card not related to the entity to pay your $46,000 damage bills at the hotels.
That was crazy,
isn't it?
Lord.
Can you have a separate card for people's plane tickets that's not related to the entity?
But again, all that Molly, holes in your brain.
It must be. Must be.
All right.
That's something else I think the defense will be relying on as well. There was talk of them having an expert and to talk about his drug use, and maybe he was using drugs so much that he wasn't able to form the intent that's necessary for some of these crimes, because there's specific intent that has to be formed. The prosecution has to prove that. So maybe, they'll have an expert on to talk about how significant his drug use was. And so he couldn't form the requisite intent.
Okay. All right. She has quite a few more questions, so I don't want to hold you. So the jury reportedly viewed graphic video footage. Okay, Kimberly, with these questions. So the jury reportedly viewed graphic video footage of some of the alleged sexual encounters this week. How might that kind of evidence influence their perception of consent, coercion, and overall credibility?
Now we're speculating because we haven't seen the videos.
No.
So if...
Sidebar, wait. I don't know if you saw this in one of my summaries. Although they did not see it,
You could
someone's
hear.
headphones were off and it was by a microphone, so the court could hear.
I wonder if that was intentional.
Hmm.
And did it get awkward? Like, at what point was somebody like, we can all hear this?
No, everybody was on the same page. Shh,
And
nothing. Don't say nothing.
pretend like we don't know. But how
Right.
awkward is that, where you just hear some moaning and a little bit of indiscriminate chatter in the back? But from the defense perspective, if it looks like the named victims, Cassie, etc., are into it, they might be using that as arguments for consent, even though their testimony was, we didn't want to do it, but we were trying to keep him happy by doing these things.
Yeah.
So that could end up being a wash. But it's one thing to hear about it, but probably to see the actual video of what they heard so much about has to be pretty jarring. It's one thing to hear about all this baby oil and lubricant and red lights and heels, and probably another to see who's supposed to be his girlfriend potentially engaged in sex acts with somebody else, with him in the background
Directing it
and doing his own thing with, I guess, with the mask on, like no one's supposed to know it's him.
I will say, based off of all the speculation and conspiracy theories leading up to this case, there were all kinds of stories about these freak-offs involving other people, other celebrities, people.
Right.
None of that came out in this case so far.
And I actually think the prosecution may have erred in name dropping so much in the beginning. And I think we did talk about this a little bit before, but it was insinuated that there was a like basically that the white parties in the Hamptons were one big freak off. Like, that's what the insinuation was. But it seems like this was contained.
Yeah.
This level.
From what I've heard, literally when I had my live show in LA, 2 different people that did not know each other had their own, oh, I was at a Freakoff story. Yeah, you should have came to the LA show. I was like, what? So watching this case, I was like, but that never came up.
And does the sheer volume trip you out, Kemp?
Yeah.
Like, for someone who was running multiple businesses, multiple children, recording out the whole 9, touring, like, how did you keep this schedule? Could you imagine this level of, we'll call it activity,
and drug
use so routine over so many years?
But let's keep in mind, though, he wasn't doing the hard work.
That's, you know what?
For 3 to 4 days.
Like, in the text of, like, I'm only available to do it on this day because I need these days to recover, schedule my IV. Like, this is wild and pervasive. Yeah. Just the timing alone is wild.
Yeah. The timing alone, the drugs that were taken, and the literal abuse that was happening at the same time. I can't imagine. I know a lot of people are trying to turn these victims into villains. No, the villain, point blank period, is Sean Diddy Combs.
I agree, but that's what the defense is going to do. And to sort of one of Kimberly's questions, what the defense has the luxury of is an approach of throwing everything against the wall and seeing what sticks, even if it's inconsistent. If it's, he was so hopped up on drugs, he didn't know what he was doing, so he can't be accountable. And Cassie consented to it. So, it's not a crime to begin with. And it was his personal, not his actual business. And he's not the one who ever set this up. They can throw all these things that aren't consistent with each other, and it doesn't matter. Whereas the prosecution has to have a very consistent one through line theory about what was going on.
What does it say if the jury comes back quickly with a verdict?
Usually quick verdicts are guilties, usually. But then, you think back to the original trial of the century, the OJ trial, that was 9 months with 4 hours of deliberation and a not guilty.
Oh.
Usually it goes, the longer they're deliberating, the more the defense starts to get encouraged of at least a hung jury or a split verdict, meaning some guilty and some not guilty findings. So if it's quick, generally speaking, I would think it's probably guilt. Usually, and defense attorneys will even tell you that too. But
And what is quick?
this is a 6-week trial. So for them to deliberate for a couple of days wouldn't be crazy. There's a lot of information.
Yeah.
A quick verdict would be to come back the same day that they went out.
Oh,
Like a couple of hours. Like if they were dismissed to start deliberating, say at 10 a.m. and by 3, 4 o'clock, they had a verdict, that's pretty fast for as long as this trial was.
wow. Oof, we'll be watching. Okay, a couple more questions, and I'm gonna definitely let you go. I apologize, but for those that are watching or listening, be sure to like the video, or if you're listening to this on the podcast, give us a 5-star review. We're doing the Lord's work by bringing you this information, the knowledge of Kirsten Brown.
Trying to.
Everyone loved the first episode. I don't know if you saw that.
That makes me so happy. If there's nothing comes out of this, hopefully it's just a more informed public of people understanding more about the system, which this is our system. The criminal justice system belongs to all of us, and we should understand it. And then learning about coercive and toxic and violent relationships. If it helps anybody get out of one, then that's a win as well.
That part. All right. So aside from Cassie, which witnesses do you believe had the most impact on the prosecution's case so far, and why?
I actually don't think it's a person. I think it's these text messages that have been coming in over the past couple of days. And the reason I say that is because the reason these text messages can come in and they're not hearsay is because the statements are coming from Diddy. And then you're getting the other people so that you have the complete conversation. So it's very, very powerful when you can use the defendant's words to prove your case, to make your point, to start hitting some of the elements. And I think a lot has become crystallized in these text messages that are coming in, and allows you to hear from a person who probably won't testify. And this is the best way to hear directly from them. And that this is not what someone is saying after the fact. It captured in real time what was going on. That was in the moment responses to what was happening around him, not years later saying what it was.
And go ahead.
Yeah, so it's not a person, but I think that's really, really powerful evidence. I won't call it testimony, but evidence, if you will, that I think next to Cassie is probably the second most important thing.
And the downside for Diddy, he loved to send voice notes. So back to what I was saying, that sometimes it's hard to understand people's intentions in text. He loved a voice note. So
and it really allows this contrast from Grandpa Diddy in court in his sweaters and khakis and glasses, looking all demure and meek and smiling and nodding at people. And you hear him in this voice note sounding crazy. Or in the background of the Freakoff video, oiled up, directing people. So that contrast can be really, really powerful when you're getting an impression of someone in the flesh over a course of a couple weeks, and now you have something to compare that to.
Yeah. How would you assess the prosecution's overall strategy this past week? And based on their momentum so far, what do you anticipate they'll focus on in the final phase of the trial?
So this final phase has been them getting in the cell phone evidence, the receipts, kind of the nuts and bolts of the case, if you will. And we don't know what's coming from this assistant, where I think you and I both speculating that it's probably going to be significant because they want to go out with a bang. Yeah. And then I expect a very methodical, probably lengthy closing argument to really, like we said at the top, show that theory of criminal liability and how each of these facts align with the elements of the offenses so that they can find him guilty.
And Kimberly's last question was, if there's a mistrial or hung jury, what typically happens next in a RICO case of this magnitude?
The defense is going to make that motion to dismiss. Depending on the circumstances, in all likelihood, it's not granted. And the constitutional clock starts again. So they can be back in trial in quick as a couple of months, or maybe they want to take longer. And different people have different opinions about who a retrial favors. Personally, I've done very well when I've had to retry cases. I typically, notwithstanding the Karen Reed acquittal today, but that case was a mess to begin with.
Yeah.
It was a mess. but it usually goes better for the prosecution the second time because you talk to the jurors. You find out what worked and what didn't. You're able to assess your case and say, you know what, maybe these witnesses weren't as effective as we needed them to be, and you either prep them better or you don't call them at all. It allows you to reevaluate your case and tighten it up and put on a better case. And any surprises that might have come from the defense, you now know about. And so you're able to either exclude some of that stuff sometimes because the defense can surprise you, even though they're supposed to turn over their discovery. There's ways around it that they don't, so you do get surprised sometimes. So if you know what they're going to do ahead of time, you can either get it excluded because it should have never come in the first place, or you're better prepared to rebut it. So in my opinion, second trials tend to go better for the prosecution, but if you had a strong case to begin with. But for cases that are a bit of a mess, and it could lead to a plea deal. Maybe they don't. Maybe he pleads to a lesser charge for no jail time or very minimal jail time because he's probably been humbled throughout this process as well. And on the brink of potentially spending the rest of your life in prison, or you reach a deal that can get you out of prison much, much quicker, you take that. And a mistrial can humble both sides because you realize I'm not in as control as I thought I was. This really can go either way, and it can be a wake-up call for both sides to maybe be a little bit more willing to move where they weren't before.
If, let's say, he's convicted and they appeal, what's the appeal process like? What happens next? Do they bring more witnesses, or this is going
No.
to a judge?
So if he's convicted, a sentencing date will be set and he'll be assigned what's the equivalent of a probation officer to prepare a report. And then both sides, the defense and the prosecution, will file sentencing briefs, and the prosecution will make recommendations on what they think the sentence should be. They'll have a hearing, and if there's any mitigation that the defense wants to present, the judge will hear all of that and then ultimately sentence him, and then he is sent off to a federal prison on a forthwith commitment. Separately, he'll have appellate counsel, which I'm sure has been paying attention to this entire trial. You request transcripts, so they'll get a transcript from the entire proceedings. They go over the transcripts and they identify issues to be raised on appeal. And appellate issues are ones of law, not fact. So you can't appeal saying, I think this person was lying, and you have to disregard their testimony. What you have to say is, here's the legal reasons why this person should have never been allowed to testify in the first place. Here's the legal reasons why the judge should have excluded Diddy's text messages. Here's the legal reasons why the Freakoff video should not have been admitted into evidence. Here's the legal reasons why juror number 6 should not have been excluded. So you point out all those legal reasons, they prepare a brief, file that before an appellate court. The government has an opportunity for a reply brief to answer all of that. And then the appellate courts go over it and start making decisions. And it can either be they uphold the decision in its entirety, they reverse in part, they find error, but it's not reversible error, meaning, yes, this was a mistake, but something different wouldn't have changed the outcome. So the conviction stands. Or they say something so significant happened that the conviction will be overturned, and they remand it back to the trial court, and you do it all over again.
Oh my God. If Diddy walks free.
From an acquittal?
Yeah.
Yeah.
I mean, he's already facing so many civil lawsuits.
But I think those kind of get a little diminished too. Mind you, the burden of proof for a criminal trial is beyond a reasonable doubt, very high. For a civil, it's a preponderance, like 51%. So it's much lower, the standard. So while those cases might be harmed because of the lower burden of proof. Remember, OJ was acquitted for the murder in criminal court, but he was found civilly liable for their death because it's a lower standard. Yeah. I think people will still pursue them, but I think it does hurt their chances to some extent if he's acquitted.
Wow. Kirsten, we always appreciate your legal opinion on this case. I hope, I'm not hoping, you're definitely coming back. before.
There's still so much left.
Yeah. So we might have you back
the defense case.
a lot sooner, especially as the defense. Oh, I know what I wanted to ask you, because sometimes there's so many questions in my brain.
Sure.
Before we even get to a verdict, Diddy, we've talked about this during the last time, and Mark Agnifilo talked about possibly Diddy might testify.
Mhm.
Based on what we know now, based on this case not really necessarily won by anyone, do you see Diddy taking the stand now? How many weeks later? He shouldn't.
He should not. He should not. I mean, you are opening. His defense team has done a good job.
Yeah.
And if they put on a couple of effective witnesses, they have things to argue in closing argument. Like, it is going to be a tennis match. They don't go back and forth for closing arguments, but it's going to be a point-by-point comparison. And the prosecution goes twice. They argue first, the defense argues, and the prosecution argues a second time, because the prosecution has the burden of proof. So I expect powerful closing arguments from both sides.
Who do you think will give them? I just had that thought.
Question. They say that Maureen Comey is like the lead prosecutor, but I don't know them, so I don't know who's like a specialist. Usually, I mean, prosecutors have to be able to do it all, but I am not great at rebuttal argument, for example. I do a great A argument. I'm not the best rebuttal argument prosecutor. I do it, but that's not like my bread and butter.
Yeah.
So they're going to pick the one who's probably very good at connecting with the jury and very good at explaining the law and breaking it down in layman's terms. So that's who they have to go with the prosecution side. And then good question from the defense.
And I think this is where it would benefit to being inside the court, because
and
we were there, we could be like
being with the jury.
Yeah.
No, I'd be curious too if they broke it up and had two different people argue.
Oh, I didn't think about that.
Maybe, but the judge might be like, we're not doing that. We're on a timeline. Like so.
You know how he is.
I know. He's escaping me. Black defense attorney.
Xavier?
Yes, they say that his cross-examinations were very effective.
Yeah.
So it's possible they tee him up again. It sounds like Tenny has been effective. And so maybe like but I think she opened. So I bet they go with somebody different for closing.
And Westmoreland, we haven't really seen go back up there. She did the cross of, but did she do Cassie as well?
I think she did. And the talk was that she was fairly effective as well.
We haven't really seen her go up there in regards to any more cross, but it would be interesting.
We're so close to the end, but there's a long way to go. Like, this case will be won and lost in the closing arguments.
Oh.
And then we'll be waiting for those jury questions to try to get an idea about what direction they're going in.
If I get my hands on them, we're gonna have to unpack them. And Kirsten Brown, you will have to be back again, guys. Don't forget to like this video. Don't forget to subscribe to us on the podcast, because sometimes in the podcast, this is where you hear our conversation first. So make sure you're subscribed there. And we have all your Diddy updates every single day of the trial. Luckily for me,
and they're so good.
Well, thank you. I take that as the highest compliment from a prosecutor.
Oh, they're really good. Kemp Esquire for real. And Kimberly could be a paralegal.
Right,
Kimberly? Yes.
That was some good.
Those are sophisticated questions.
Yes, thank you to everyone that sent in the questions. We appreciate you guys. We will continue. That was a member exclusive. We didn't do it to the public. We did it for our members exclusively. So we'll do it again, because Kirsten has to come back, because there's still so much more to unpack and talk about. We appreciate you taking the time out, because I know you got a lot on your own caseload. So we appreciate it. Thank you so much for being here again.
Thank you for having me, Kemp. It's so fun. It's so fun talking to you about this, and I'm so glad that it's been productive.
Oh my God.
Your listeners find it productive too. I can't wait to come back.
Educational, productive. I feel like, I'm not going to, because going to law school is a whole other thing.
Just go the Kim Kardashian route. Just apprentice for 12 years.
Really? I don't know if you saw this, but I mentioned that someone on my Spotify, because you're on Spotify, you're able to comment, and they're a young person. They're like, you guys are inspiring this young person to go to law school.
Oh, I love that. I hope so. I am here for breeding the next generation of lawyers of color, women. Like, we're the ones who are going to change this profession and make it equitable. I feel passionately about my cases, and I only bring cases when I have the evidence to convict someone. But the defense plays a very important role in our system. And but for the grace of God, any one of us could be accused. And so we want an equitable system with protections in place to keep all of us safe and to hold my feet to the fire as a prosecutor. I have no problem with that.
Most definitely. Kirsten Brown, thank you so much again for being a part of our legal squad covering the Sean Diddy Combs trial.
Here we go now.